Thank you. So, right now, we will open the hearing on House Bill 5261 by Representative Stewart. Representative Stewart, if you would, take the witness seat. And at this time, let's call up John Marion as well. There's 2 seats. John, if you're here and you would like to testify. Okay, that's fine. We'll take Stephen Brown if you would. Stephen, thank you. Okay, this is House Bill 5260 we're beginning with. Thank you. Go ahead.
Chairman Casey and members of the Committee on Municipal Government and Housing, thank you very much for the opportunity to talk with you today about House Bill 5260. House Bill 5260 is about transparency, accountability, and democracy. It would allow the public to easily learn about the legal actions in which their local government is the defendant and the corresponding costs of that defense. You might ask, why does the bill focus on legal actions in which local government is the defendant? A city or town's decision to fight a complaint is in effect a policy decision. It involves setting a priority for expenditure of public resources. Residents should be able to know how their local government decides to spend the public's money. With this information, residents are in a better position to discern whether members of the local government are being responsible stewards of these resources. It can also help us better understand if city or town governments are engaged in activities or have laws that have had their constitutionality challenged. This bill is inspired by my experience with the city of Pawtucket. This past year, Representative Cruz and I were co-plaintiffs challenging a Pawtucket ordinance that prohibited posting yard signs for political candidates on residential property more than 30 days before an election. Although there had been several court decisions dating back decades that ruled durational limits on displaying political signs unconstitutional, including successful suits against similar ordinances in Cumberland, Warwick, and North Kingstown, and despite the ACLU alerting Pawtucket in 2018 about the unconstitutionality of its law, the city attempted to enforce its ordinance, forcing us to sue. Because we won the lawsuit, the city of Pawtucket was responsible for our legal costs and minor compensatory damages. In all, Pawtucket paid $19,311.77. This does not include the city's own legal costs, which were not disclosed. I knew lawsuits were expensive. I had no idea how expensive until I was involved in this case. In our case, those costs were avoidable. My own involvement in this lawsuit led me to wonder how many other cases were in process and how much money is being spent, not only in Pawtucket, but in every city and town throughout our state. Of course, information about such lawsuits should be provided upon request pursuant to Rhode Island's Access to Public Records Act, or APRA procedure. But this legislation aims to put the onus on our cities and towns to post this information rather than on residents to seek it out. APRA is complicated to use, it's time-consuming, intimidating to non-lawyers, and can be expensive. In fact, there was even a lawsuit against the Attorney General for charging onerous fees to copy documents requested under APRA. The rules of the Rhode Island judiciary state that every court shall provide for public access to case information, but for non-attorneys, that access seems limited to the docket sheet. The docket sheet lists information like parties to legal actions, case events, document filings, or other activities in chronological order. But this is of little use if you are a constituent trying to figure out if you support how your local government manages its public funds, because it doesn't give any of the expenditure information. And it doesn't help you decide if you should attend a city council meeting, for example, to inquire about such expenditures. In closing, House Bill 5260 seeks to provide Rhode Islanders with a more comprehensive understanding of their local government and encourage meaningful engagement with it. Just one more time in closing, the bill is about transparency, accountability, and democracy. Thank you for your time, and I'll do my best to answer any questions you may have.
Thank you, Representative Stewart. Are there questions from the committee? Okay, first, Representative Morales.
Thank you, Chairman. Thank you so much, Representative Stewart. And so throughout your research when developing and drafting this bill, were you able to identify any Rhode Island cities or towns that are already providing this level of transparency in terms of disclosing this information?
No, I have not.
Thank
But I
you.
don't know if that's out there. I just
Yeah,
didn't
so I
find
think
it.
that is further reason as to why legislation like this is necessary, because the matter of the fact is cities or towns do have the administrative discretion to start doing this. However, it seems unfortunate that many haven't started the process just yet. Therefore, legislation would ensure that that information is available. Thank you.
Thank you. Representative Newberry?
Thank you, Mr. Chairman. So Rep. Stewart, I have no problem with this in concept at all. I think transparency is good. But I just want to point out a couple of practical problems that may be fixable, but in the legislation itself. So there's four elements essentially, and number one is easy enough to do. Number two, though, provide a short summary of the substantive issues of the legal action. That begs the question of who's going to write that. Lawyers are very skilled at saying as little as possible when necessary, and if that's going to be written by the city or town, and the city or town wants to minimize what the issues are against the city or town, assuming the city or town's a defendant, they're going to provide almost no information. They'll just say breach of contract action brought by property owner or something like that. It won't tell you anything. You know what I'm saying? So on the other hand, court cases are public. The dockets, not just the docket, but the public filings are public. Maybe you could have the complaint, they have to post a PDF copy of the complaint in the action. Now, the complaints are obviously one-sided no matter who files them, but at least they're going to lay out most of the time what the details are, would give people a better understanding of what the case is about. Number three is obviously fine. Number four, I think you may have a problem. I saw one of the written things touched on, legal cities and towns touched on this. Different cities and towns have different setups for solicitors. For example, City of Woonsocket, I know Chairman Casey will correct me if I'm wrong in this, but I believe they have a full-time city solicitor as an employee of the city. Now, a lot of smaller towns have town solicitors who are on flat fees for routine work, but for special litigation, they may hire somebody else. So if that's the case, that's fine. If you're hiring a law firm or maybe even the solicitor themselves, but at a different rate for a specific case, then you can lay out the cost of the case. But if it's a smaller matter, remember, I know you're really trying to target the bigger cases, I get that, but the statute has to be written to cover everything. If it's a smaller matter, it may be that the in-house solicitor is going to handle it, in which case there's no way to break out the costs. So I'm speaking hypothetically about Woonsocket. I don't know what they do, but I could see the full-time city solicitor handling some small breach of contract matter that's worth $2,000. They're not going to farm it out to outside counsel or charge a separate rate. Depends on what their specific relationship is with the city council or mayor, whoever hires them. And every town's going to have a different arrangement. Do you see what I'm saying? So there's going to be some practical problems to doing number four. And I'm not quite sure off the top of my head how you fix that. If you can fix it, I'd be in favor of it, but I think there's going to be some issues there. Maybe you just simply have to make it disclose all costs and expenses related to special rates for litigation or something like that. But as written, it's not going to work. That's all I'm saying.
Thank you, Representative Newberry. Are there any other questions for Representative Stewart? Okay, then we're going to move to our first witness. Steve, go right ahead, please.
Thank you, Chair, members of the committee. Stephen Brown from the ACLU of Rhode Island. I'm here to testify in strong support of this legislation. I want to thank Representative Stewart for putting it in. This is, as she said, really just a matter of transparency and accountability at a few levels. The one that Representative Stewart mentioned, I think, is key for taxpayers to be able to easily find out how much money their city or town is spending on litigation and what sort of litigation. But I think there's a second value, and that's to the municipalities themselves. And I want to explain a situation that we dealt with just a few years ago that really shocked me. There was a public body in a municipality that was involved in a lawsuit that we were concerned about and we thought was frivolous. And we were interested in finding out how much money the town was spending to pursue this litigation. And much to our surprise, the public body was not able to tell us that, and that's because their outside counsel who handled their litigation provided them a monthly bill that did not break the bill down by particular legal action or issue. They simply had these general categories: grievances, negotiations, labor. If you wanted to find out how much was this case costing the taxpayers to bring, we had no idea, and the public body itself had no idea. So we think passage of something like this would be helpful to public bodies as well. They should know, as a matter of fiduciary responsibility, are they spending tons of money on a case that, upon reflection, maybe they really shouldn't once they realize how much they're paying for it. So for those reasons, we hope the committee will give favorable consideration to it. I believe I haven't seen the League of Cities and Town testimony, but I believe any problems can be very easily addressed to deal with any concerns they have. But we think the public interest would be greatly served by passage of this bill. And with that, I'll be glad to answer any questions.
Thank you, Stephen. Are there any questions for Stephen? Representative Morales, go ahead.
Thank you, Chairman. Mr. Brown, similar to the question I asked Representative Stewart, do you know of any municipality in Rhode Island that is currently disclosing this information publicly on their website?
No, none that I'm aware of. I will say I have seen a couple of times in minutes of meetings where a public body has sort of laid out, this is the bill we're paying and it's for these reasons, but I haven't seen anything on a website.
Well, generally, there's a lack of transparency there.
Absolutely, yes.
Again, I think this further reiterates the need for this bill. Thank you.
Thank you, Representative Morales. Are there any other questions for Steve Brown, please? Okay, thank you. Thank you both for your testimony. We're going to bring up the next two folks. Let's have Pat Ford, please, and Ian Ridlin. Pat, you can go first when you're ready.
Good evening, everyone. My name is Pat Ford, and I am the general manager of an organization here in Rhode Island called the Coalition Radio Network. And while it may be considered unusual by some for a member of the independent media to testify, I would argue that my presence at over 100 city council and school meetings annually across the state of Rhode Island, from Westerly to Cumberland, gives me an unusual perspective on municipalities and their behavior. I rise in full support of this legislation. I applaud Representative Stewart's deep dive into the type of oversight that should be a normalized component of government management. Give an example of something the state has done well that's similar in spirit. A few years back, the state of Rhode Island enacted legislation requiring full disclosure of the borrowing costs, interest, and fees surrounding bond offerings at the state level. The impact has been profound. Transparency exists. We now have an informed electorate. The legislation has the potential to have this same type of impact with the harsh light of transparency. Some anecdotes. The city of Pawtucket holds regular meetings of a city council subcommittee called City Claims and Pending Suits. I am a regular attendee of these meetings. Last week, the city elders ruled over a pair of potholes and a fallen tree, yet gave no mention to the 3 impending lawsuits resulting from claims surrounding the alleged misbehavior of one Officer Daniel Dolan, recently found innocent of a police-involved shooting off duty, yet the subject of no less than 3 areas of civil litigation. And that's the ones that I know about. The town of Narragansett in 2022, in their most recent attempt to enact city ordinance about how many roommates you can have, a Superior Court judge ruled on Monday that stopped Narragansett from enforcing this controversial ordinance, limiting the number of college students that can live in rental housings. Notice a common denominator here. All of these cases involve Superior Court. This is not the jurisdiction of town traffic courts or, quiet meetings in back rooms. This involves sophisticated lawyering and the most expensive, the most important part of our legal system, literally bringing it to a grinding halt over a case that's already been decided 3 times. I can't tell you how many times I've had heroes from the American Civil Liberties Union appear on our little media effort to describe, and I'll add a little bit of sarcasm and humor, to, again, what we call municipalities and town councils gone wild. The town of Smithfield attempted to write their own medical cannabis laws.
Excuse me, Pat, just before you continue, and I love what you're doing, that's fine. If there's another instance where you're going to mention a specific person's name, I'd like you to omit the name.
Okay.
I
It's
appreciate
okay
it.
to mention the town, though.
Yes, that's fine.
Fair
Thank
enough. All right, so the city of Smithfield, the town of Smithfield, decided that they were going to enforce their own medical cannabis laws. I don't know from what legal planet they came from. I'm sure in their minds it was well-intentioned. The town of Barrington, a school committee, apparently with the full support of their their school department solicitor, thought it would be ennoble to institute their own vaccination mandate, ultimately firing 3 teachers in their zealous pursuit of science. Regardless of how you feel about that, that's typically not the, if you will, the routine of a municipality. This case, by the way, is still mired again in Superior Court. And it appears that this time the defendants will prevail. Again, the potential cost to taxpayers being, well, countless thousands of dollars, I would imagine well into 6 figures. This same type of behavior, by the way, exists at the state level. The state of Rhode Island has been in court for nearly a year and a half fighting a largely discredited mask mandate. Incredibly, the case is still in the discovery phase after a year and a half. The effective cost of state attorneys and their associated costs must be staggering. Of course, the taxpayers will never truly know, given the difficulties under our current opera system, in actually getting a response. The governor, by the way, recently instigated a jihad against the homeless here at the State House, with the governor hiring private counsel from the firm Adler, Pollock, and Sheehan, clearly one of the most sophisticated law firms in this part of the country, probably with resulting fees. And again, we will probably never know, despite efforts by myself and other folks in the media to get them to disclose the true cost of doing so. As I said at the Coalition Radio Network, we call this town councils and government gone wild, where either the egos of newly elected municipal or state leaders, flush with their newfound power, become masters of the universe, or in many cases simply attempt to fulfill wildly speculative campaign promises. It drives normally rational adults to rule on matters diverse, regardless of the advice often of their city solicitors or their own personal background. In the aggregate, this has cost Rhode Island taxpayers millions in legal fees, and while many cheer the pursuit, when the noise of the court cases fade away, it is in fact these same taxpayers left holding the bag. Or as the cartoon Pogo once stated, we have met the enemy and it is us. Finally, under generally accepted accounting principles and most SEC laws, private businesses are expected to account for liabilities. Under reserve accounting, an entity must make a reasonable projection of the potential cost of litigation, whether they be directing it or be the recipient of it. Government should follow these same dictates. Additionally, I would suggest that in addition to the cost of outside attorneys, a calculation should be made as the internal labor costs, as countless state and municipal lawyers, many of them often having private practices, can indulge in, again, countless amounts of money with virtually no accountability. It's only in the passage of this legislation that can lawmakers be held accountable for their behavior. Only then can voters truly judge every 2 to 4 years the efficacy, the honesty, the seriousness of the people that they elect as leaders. So I urge you to pass this legislation. Thank you.
Thank you, Pat. Are there any questions for Pat from our committee? Okay, at this time there are none. So we'll move on to Ian. Ian is from the Rhode Island Interlocal Trust.
Thank you, Mr. Chairman. For those of you who aren't aware, the Interlocal Trust is a statutorily created entity that it, among other things, besides providing risk management services to municipalities and school districts and special purpose districts of the state, also administers essentially a self-insured program for those. We have the large majority of cities and towns and school districts as insured members in our property liability pool, and I won't touch on the other pools because for purposes of today's testimony, really liability is the key inquiry. Representative Newberry raised some obvious practical concerns with this proposed legislation, but I'm going to start right up at the top. which is that there's a threshold question here. Does this apply to active lawsuits, or does this apply only to those lawsuits that are closed, right? They're finished, there's a resolution. Because if it applies to active lawsuits, that's going to be a huge problem. There's a number of different things that are going to happen in here, particularly with respect to trying to describe what is going on in the lawsuit, who's doing what. You start to talk about fees. Well, fees are going to have to disclose what you've got for experts, and sometimes you have an expert that's not disclosed yet, and you haven't determined whether or not you're going to use that expert. It is going to put cities and towns, basically it's going to force them to litigate with both arms behind their backs, whereas there are all these other protections under the rules of civil procedure that apply to every other defendant that are no longer going to apply to cities and towns. It makes absolutely no sense whatsoever. Now, if we're just talking about cases that are closed and people want to know what, okay, this case was closed, this is what it was about, this is what got spent, whether or not we did, something. Say what you want about the actions of individual city and town councils or school committees, right? They're all human beings. They try to do their best. We elect them. They do what they can do, right? At the end of the day, though, if you want to find out what happened, that information is all publicly available. Nobody's hiding that information. I can go on the website I can pull up the court's website right now and find the dockets on all of this stuff. Some of the issues that Representative Newberry indicated, like trying to do a summary of what was happening in the litigation, why they did it. Those are mental impressions. That's going to be testimony at the hearing. Again, nobody's trying to hide stuff. And if the goal on this is to prevent midway through some action that some city or town council is taking that members of the public may or may not agree with, it's not going to work, because you're not going to know until after the case has already been resolved what was spent in terms of fees. Listen, everybody knows what the cases are. They know what the subject matter of the case is. It's written in every paper. I can tell you during the course of the issue with the Barrington school teachers, for example, that was all public. Everybody knew exactly what was going on. You could go to the school committee meetings, you could see it. You could read it in the papers, you could see it on the news. Nobody's hiding this information. So this is really an effort to try to make sure that all the cities and towns are putting their cards on the table, presumably in the middle of litigation, because there's nothing in here to the contrary that says not active. There's nowhere in here where it's defined the term legal action. If it was defined, that would be a little bit better, but it's clearly not defined. So this thing suffers from a million different problems. I have no problem at all with the idea of transparency. And on behalf of all the members of the trust, we have to defend these cases, okay? And lots of times that people bring frivolous actions against cities and towns. Doesn't matter what it is. When somebody gets named as a defendant, anybody who's ever been a lawyer, talked to a lawyer, knows that anybody can sue anybody at any time. Cities and towns are big pockets, right? School districts are big pockets. They get sued all the time for things, okay? It doesn't mean that they're engaging in ridiculous and frivolous activities. So I think that this is very well intentioned. I just don't think that there's any way that this is workable. What is available publicly is available publicly, and nothing more should be. So I'm happy to entertain any questions.
Thank you, Ian. We have a few questions. First, Rep. Dawson, go ahead.
All right. For your benefit, I also am a lawyer. I've been practicing for 27 years. I'm a little confused by your argument. To sum it up, I think what you're saying is that the lawyers representing the city can't do their job if people know what they're doing. Am I stating that incorrectly?
You are.
What did you mean when you said, why is the city or town going to have their hands behind their back because they have to disclose who their experts are or how much they paid them?
Because, as you know, with the rules of civil procedure, they're not going to necessarily need to disclose experts that they're not going to use at trial, for example. And that's just one instance.
I don't understand why that's a problem. Why is that a problem? They're having you list, whoever is defending them, the number of experts that were consulted and how much they get paid. I'm presuming that whoever is representing the city is doing a proper job in the normal course. This is what we do. What you just said, I don't think anybody here has any problem with that. You have to consult experts to get expert opinions, and you disclose that. How does that hurt your defense?
Rep. Dawson, I think Representative Newberry wants to take a shot at answering your
I
question.
can answer that specific question. And I should have thought of this myself. You raised that issue. I do professional malpractice defense. So I hire expert witnesses all the time. And sometimes you hire experts that give you opinions that turn out not to be good for your case, and you deep six them. But if I have to disclose that I hired them, that's a serious problem. It breaches work product privilege and all kinds of things. It really does hurt the city's defense. Now, there might be ways to redraft this to avoid that, but the way it's written, disclose all costs and expenses, I don't know what that means, because does that mean itemized? If it means a total bill that I've spent on the city, I've spent X dollars, and I don't have to give any more information than that, then no one's going to know if I consulted an expert. But I'm thinking, I'm going to be careful I say this, I'm thinking of a case right now where I have an expert that I hired, and we're debating whether to even use them for trial because the opinion was not very good for us. It was in between. That is, I hadn't thought about that. I'm glad you raised that. I live this, and it is a serious problem if that's the intent of this. Again, if you want a lump sum, not broken down, I spent 10 grand on legal fees, 10 grand on experts or whatever, that's different. But that's a serious problem, Chairman. Really
Okay,
is.
correct me if I'm wrong. Ian, I think your point was that this is for cases that are currently being adjudicated and not decided.
And that's what's unclear from the legislation as proposed. It doesn't clarify what a legal action is.
Rep.
Is it
Dawson,
pending, is it not?
I think generally he's been speaking of a case that is currently open and not decided. It's, for better or worse terms, it's, you don't want to show your hand as a poker player.
Perhaps we can work on the language there.
Yeah.
But I still don't see where, what the money that you've spent and the efforts that you've made, undescribed expert witness or whatever, how that's going to affect you. I see your point is you don't want the other side to know what you're doing.
I think if the
sometime.
case has been adjudicated, then there's no problem.
But that, again, not clear. The other issue that I will kind of as response to that is there's a very specific reason why when cities and towns go into executive session to discuss litigation, that's an exception to the Open Meetings Act and the Access to Public Records Act. It's because they recognize that you can't essentially, discuss litigation strategies in a public forum without adversely impacting the defense. And in this case, remember, say what you want about your elected officials in cities and towns, but they do represent the people in those cities and towns. They're doing their best. And if they put themselves in a position where they jeopardize the cities and towns, they've jeopardized all of their taxpayers as well. So they're doing what they're supposed to be doing. And candidly, the other piece of it is, as I said, most of these entities participate in the trust, and so as part of the program, defense costs are covered under the cost of their insurance. So the ability to break some of that stuff out is going to be, again, difficult. And it's not necessarily attorney's fees that are being paid by the municipality or ultimately the taxpayers. So you're not going to get the clarity, I think, with which, the intent of this statute. I just think there's myriad issues with this drafted.
I just don't agree with you.
Okay. Why we're here.
The list here is rudimentary. We just want the basics, which I agree with you. I'm an attorney. I can find anything I want. I just Google Providence and I'll see everything that pops up and I can look at all the stuff in there. I don't want to do that though. But no one's asking you to get into executive session. I mean, obviously lawyer-client privilege still exists, and there's nothing in here asking anyone to divulge any private communications and/or strategies. It's just, here's the lawyer, here's the rudimentary 2 sentences, this is what it is, this is how much it's costing. And I take your point relative to some things you don't want to disclose who you're talking to, but I think they just want to see what are we paying on this potentially frivolous, or I tend to think most people recognize that litigation is expensive, and sometimes the city has to do what it has to do, and it has to have trials and have things and defend just causes where there's an honest disagreement. But I don't follow, you're conflating that with, you're going to get into this, you're going to have to open up your file and let everyone look at it. I don't read this that way. They're asking for rudimentary facts. This is what's going on. You don't agree with me?
No, but that's
Okay.
what it is.
Can I answer your question?
Unfortunately, Pat, you cannot.
I'll get him in the hallway.
But we can talk after, and that's fine. Representative Batista, go ahead.
Thank you. I had a couple of quick questions, and I want to incorporate by reference many of the points that Representative, I want to say, I'm thinking Dawson, but I don't want to call you the first name. Sir, I'm sorry, could you please tell us again who you represent or who you're here on behalf of?
It's the Rhode Island Interlocal Risk Management Trust. We're a statutorily created entity, and we exist for the purpose of insuring cities and towns in Rhode Island.
Can you say the name one more time?
Yes, Rhode Island Interlocal Risk Management Trust.
Insurance company?
No,
No?
no.
Okay. And you're saying that you represent the cities and towns in cases like this, or cases that could come up?
We have programs, risk management programs. We administer a self-insurance pool for cities and towns that participate. We are specifically in our enabling legislation, not an insurance company.
Okay, no, I appreciate that. And does this group work with every municipality, or is it just a relationship with certain municipalities?
We have as members 35 of the 39 cities and towns, 34 of the 36 school districts, and about 55 special purpose districts, which are water districts, fire districts, and the like.
All right, I appreciate you clarifying that, because at one point when you said you represent the cities and towns, I thought you meant like as an attorney, folks who defend the city, but I appreciate that distinction. The last thing I would say is that I feel a lot of the ways that the points that were made up earlier, and there was maybe a point or two where you said like there's like a million problems with this bill and this is completely unworkable. It sounds to me that maybe there's like maybe one problem, at least as I see it, and it's that it's too broad, is what I think I hear what you're saying. And I guess my question to you is, wouldn't most of these concerns go away if we said that this bill applied to cases that had settled, cases that were over in some way? In other words, isn't that really the one main concern?
Which is fundamentally rewriting what this amendment is.
Okay.
And that's the problem. It fundamentally changes what's here.
Okay. All right, so it doesn't seem that unworkable then.
As drafted, it's absolutely unworkable, but could it be fixed? Sure.
Okay.
But I think what happens is when you go about fixing it and you deal with all the practical problems, what you end up having is everything that is already accessible to the public. It's just that they don't want to go out and find it themselves. They want somebody to put it together for them and hand it to them.
Thank you very much.
Thank you, Rep. Batista. Rep. Speakman, go right ahead, please.
Thank you very much. Hello, Mr. Ridlon. We worked together when I was in municipal government. Going out and finding legal documents is easy for attorneys, but it's not for your average citizen like myself. So I agree with the spirit of this, this proposal, and I commend Representative Stewart for bringing it forward. I get what you're saying. I've been in executive sessions in town councils where you have attorneys telling the town council, most of whom are not attorneys, that they need to proceed with this suit and take on the taxpayers' behalf, some pretty hefty attorney's fees. And these are attorneys recommending to us that we hire other attorneys to take on big expenditures for the community. So I do think some kind of transparency is appropriate, and if you could work with the sponsor to find a way to make this workable. I do think ongoing lawsuits, though, I mean, things can go on for many years and they can be very expensive. And it seems to me that the representatives of the public should be able to understand exactly what they're getting into when they say to the lawyer, sure, go ahead with the suit, and that the people to whom they report, that is, the taxpayers, have a right to know basically the financial commitment that's being made. So if there's a way to work this out that the public can see what's going on, I think we would have made some progress here. Thank you. Thank you, Chairman.
Thank you, Representative Speakman. Are there any other questions for our witnesses? Thank you, gentlemen. I appreciate your time. We do have John Marion here listed as a witness. I do not see him in the room. So before I close the hearing on House Bill 5260, if there are any other comments from the committee, I'll accept those. And if there's anyone in the room who did not sign up who would like to speak or has decided they would like to have something to say.
And I will say, Mr. Marion did submit written testimony.
Thank you. Thank you. So there is written testimony if you check the documents for today's hearing. With that, I will close the hearing on House Bill 5260.